Thank you everyone for being the audience for the finals for the second Nalsar Mediation Tournament. CAM presents Nalsar Mediation Tournament in collaboration with IAMC. We have a very honorable five-judge bench for today's session. Introducing the bench for today, we have Honorable Justice Anil Sinha from the Supreme Court of Nepal. We have Honorable Justice Naveen Rao from the Telangana High Court. So we have Ms. Ekta Bell, from a partner at Samvad Partners. We have Dr. Anirban, our own professor at Nalsar, an expert at mediation. And we finally have Mr. Tariq Khan, the registrar at IAMC. With no further ado, we shall begin this mediation session. With the permission of the Honorable Bench. Please go ahead. Thank you.
So if I may I proceed? Greetings, parties. I am James and this is Emma, and we'll be the mediators for your session today. Now, before we actually enter into more details, I would just like to confirm that the parties are comfortable with the settings. Is there anything that we need to do to make you more comfortable?
No, very comfortable.
Okay, so if at all you want anything to be done, please reach out to us. Don't hesitate. Now, I would also like to thank you, both the parties, as you have taken a Sunday off from your busy schedule to be here with the enthusiasm to sit, talk, and come to an amicable solution, and by that, share a win. Now, what I have with me right now is the NDA, that is a non-disclosure agreement that both the parties have signed before you came for the session today, which in itself is a proof of the confidentiality that this mediation process offers. Now, to introduce myself, I'm James. Full name is James Bond. I'm a certified mediator from the Indian Institute of Arbitration Mediation. I've been a practicing mediator for the past 10 years, also in the field of commercial mediation. Now, my co-mediator will be introducing herself when it's her turn to speak. Now, just to ensure better clarity, can I please request the parties to introduce themselves?
Absolutely.
I am Rahul Khurana, the founder of Syntax Error and an inventor.
Hello, I am Jane Doe and I'm the legal counsel for Ms. Rahul.
Good afternoon, everyone. My name is Joy Dash. I am the Chief Executive Officer of Syntax Error Private Limited.
Hello, everyone. My name is Karishma Verma, and I'm the counsel on behalf of Mr. Joy Dash today. My preferred pronouns are she and her, and you all can call me by my first name, Karishma. Thank you.
Perfect. Once again, to ensure, am I right to say that all the parties present today have the capacity or the competence to enter into any kind of settlement, if at all we do today?
I do have capacity to enter into agreements on behalf of the company, and Karishma has authority to represent the company.
I do as well.
I do as well, yeah.
Okay, so now that part is done. I am aware that both the parties have already sat for quite a few sessions of mediation already. So I'm assuming that through that, the parties is already aware of the process of mediation. And I'm also sure that your counsels would have already explained to you how the mediation process works. But I still feel a bit obligated to give you a bit insight into the key features of mediation. Being neutrality, that is both of the mediators does not have any prior commitment, or there's no conflict of interest between the mediators and the parties present here. Similarly, impartiality, which means the resources or any opportunity that is given to one party will definitely be given to the other party as well. Now, regarding confidentiality, as I already said, the agreement that you have signed in itself is a proof that whatever is being revealed here or discussed here will stay within this room, and it will not be admissible before any court. Okay, so with that, I would like to say, also explain the process of mediation through a small example in which I look at it, and that being the two wheels and the axle of a car. So mediation process, and okay, once again, the two wheels being both the parties and the axle being us mediators. So it is because the axle holds both the tires together that they are able to go in a unified direction forward. If one of those tire is not there also, the axle and the single tire will keep circling around the same place. So we don't want that. So we as mediators will facilitate this mediation while you parties discuss and try to come to an amicable solution. Now I hand over the addressing to my co-mediator.
Hello, I welcome every one of you to the Chandigarh Mediation Center, and your very presence here indicates your willingness to arrive at a solution. I know you've sat through to let us know what they feel about the situation that has been developing for us, and for us to understand how really is it to be in your shoes. And that will be followed by a joint session. Of course, at any point of time, if you feel you have certain inhibitions regarding some information that you can't share in a joint session, either you can request for a private meeting with us mediators, or we, if at any point of time feel to better understand the situation, we can do the same. Of course, what is different from the previous rounds of mediation that you have entered into is that because we understand the gravity of the situation and how it has been developing, we have decided to extend the time for such a private meeting to 9 minutes. We understand that it is a time constrained session that we are supposed to enter into, but we'll try our best to help you look forward to a more amicable solution. And at any point of time, any party feels that they need to take a break to simmer down, gather their thoughts, think about the offers presented, confer with their counsels, we can, with the assent of both the parties, take a 6-minute break, and 2 of such breaks can be taken throughout the session. Also, all we ask from the two parties throughout the course of the session is that you provide the other party with an uninterrupted period of time, following the rules of common courtesy. And of course, any questions that you have while the other party is speaking, you may note down, and we'll get to that after their time is done. Will the parties like to set any ground rules to that regard? Okay. So if there aren't any questions, we can, of course, as it's customary, begin with the requesting party for them to help us know their perspective and what they expect out of this session. Can we go forward to that? Okay. So I request Mr. Rahul to let us know what they feel.
Succinctly explaining the mediation process. Hello, Joy and Karishma. I'm sure you know, Joy, especially, that I find no joy in these business communications. However, my able counsel has advised me about the merits of the mediation process and insisted that I pursue it. She has also assured me of her support throughout this process.
Yes, I've indeed spoken in great length about the merits of mediation, just as our mediators have done right now. And along with that, I would just like to set it out in the forefront that I am here indeed in an advisory capacity. And I'm also only going to be placing forward my client's interest to further the communication. And additionally, I've advised my client to have a very open mind today coming to this session. Yeah, off to you.
Indeed, Jane. So, Joy, you are aware, since we met back in 2013 over Mai Tais, that I am foremost an inventor. I like to steer clear of business communications. You were there for that. Even today, I like to focus on inventions that are affordable, accessible, and accurate. Do you see this ring? It's no ordinary ring. It's one such ring which has a thermal sensor. So the moment my body temperature rises or dips abnormally, the color of the metal changes. Such are the inventions that I wanted to work and focus on. And especially through the developments in the past few months and these mediation sessions, I have renewed clarity that I want to focus on my research and inventions. Joy, even with you, I feel like today you're a different person whom I met over my ties in 2013. But in this session, I want it to be fruitful for me as an inventor, but for you as well. I understand that holding personal grudges and holding grudges should not keep us from utilizing our time, this time we have spent in these mediation sessions. It takes a lot of effort for me to put myself through these business meetings and keep myself away from my laboratory. Having founded this company, but I cannot help but feel a little concerned about the state of affairs at the company. So I am interested today in delving into what we could do for the company and, more importantly, its people. I hope that in today's session, we delve into the interests of all stakeholders, you, me, syntax error, and its people. Right, Jane?
Yeah, indeed, indeed. My client has expressed her interest in ensuring that this process is fair for all stakeholders involved in this. My client, Ms. Rahul, believes it is necessary to get an understanding of your vision moving forward with respect to the company's dealings and functions. We've faced multiple hurdles so far. However, moving ahead, my client would like to focus on how we could remedy the past mistakes engulfing the company at the moment, and what our ideal position should be as both the parties involved here. In lieu of the same, and I'd like the mediators to take note of this, the two primary interests that we have today and the two primary, let's say, questions or stances that we're taking today is first, with respect to the future of the company. We would like to know what your vision is, let's say, about the next thing you do about the functioning of the company. And the second is about future collaborations. My client, Ms. Rahul, is indeed actually very keen on, let's say, collaborating in the future if that ever comes up on this table today. So that would be our primary interest, and off to the other party.
Okay, so just to clear everything out and for a better understanding, I'll be summarizing your opening statement as a few points. Just let me know to add on something if I have missed anything at all. First of all, you still want to continue your research and development. Secondly, you are concerned about the state of affairs at the company. Third, you would like to discuss with Joy regarding the interests of the stakeholders. Fourth, you would like to get an understanding regarding what Joy has in mind for the company's future. And then you also want to discuss about the future collaborations that you could have with the company. Is there anything that I missed?
Correct. So when you talk about, just a clarification, when you talk about research and development, I think we're not really saying specifically to the company, but just inventions in general. The fact that my client would like to focus on inventions moving forward, yeah.
Noted. Thank you. Joy?
Thank you so much, James and Emma, for explaining the process of mediation so well, especially that analogy about the wheels and the axis. I think we should keep its spirit in entire mediation round, understand it, and use it effectively. My name, I did reintroduce myself. My name is Joy Dash. I'm the Chief Executive Officer of Syntax Error Private Limited. I'm here to represent my company with my counsel, Karishma. She has been with the company since several years and has been handling all the commercial and non-commercial matters. Moving forward, I would like to go back in time when we met Rahul and you talked about how we met at Maitai, and you were pretty disappointed that even though you had a product, there were no takers for it, there were no customers, and you almost felt like shutting the company down and being a consultant. And that's when I feel I was the right person at the right time, when I knew I had connections in hospitals and medical test centers. And I think we made a great team because you were great at your art and innovation, and I handled the business side of the things. There were some difficulties in the business. I'll not deny them. We had difficulties in our relationships. Despite having 4 or 5 rounds, we're still not able to come at a solution. But I'm very hopeful that this round is something. I have feeling that in this mediation session, we will come to an agreement where everyone will win. I'm a businessman at heart, and I believe in a win-win-win situation. My counsel, Karishma, will be giving her opening statement, and she will be telling us the interest of the company, the agendas we like to keep. So over to you, Karishma.
Thank you so much, Joy, for explaining your side of the story to everybody. Thank you, Emma and James, for actually explaining the process in such a crisp manner. I'm very sure Joy is all the more comfortable in this process in today's session. Thank you, Rahul and his council, for still willing to have this session even after when we have already done with 4 rounds of session with no actual conclusion. I think it actually shows that how both the parties are fighting amicably to come to a solution and finally go back homes with happy faces. J- I have, as Joy already mentioned, I have been a part of this company handling the legal department and all the commercial and non-commercial cases since many years now. And I think I know how the management of the company is, how Joy has been working, and how this company has grown since so many years. Just to actually confirm everybody here that I am only in an advisory capacity today, and any decision taken would be solely by Joy, and anything when it comes to the company would be finalized uh, by Joy, who is coming here as a representative of the company. This is solely a client-driven process, and I won't be getting technical. So just because a council is sitting here does not specifically means that any legal jargons or concepts would be used here. But I want to make sure to both the parties and both the clients that if at times there are few of the technical problems or solutions given on the table, I may help both the clients to get out of those technicalities so that it just eases out the process. Now, without taking further time of anybody here, I think we can move on the main point of agenda today, which I discussed with Joy, and we finally came out to one very common agenda. And I think when I heard the agenda of Rahul through his counsel, I think it made both me and Joy happy because we were really happy seeing that how on a common ground we both are thinking in today's session. So we only have one main agenda for today's session, which is actually discussing the future of the company with regards to the current problems. It actually summarizes both the agendas which you have put on the table today, which I think brings us on a similar grounds. With that, I think I'm very hopeful for today's session because I think both the parties understand the consequences of any legal proceedings, how much of time and money can be wasted. So I think it's in the interest of both the parties of having a solution in today's session. I think that's all from my side. Over to you, mediators. Thank you.
Thank you. Thank you. Knowing the stance of both the parties and the interests and positions that you hold enables us to better understand where we can go forward from here. So, looking at your stance, Joy, it kind of made me understand that you both come from a very common ground of seeking to ensure the future of the company. And of course, that has been a widely talked about issue regarding the company in this in your opening statements. So I think while setting the agenda, we can broadly set the agenda as the future of the company per se, whereas we can delve deeper into the relationship between Joy and Rahul, essentially, and then talk about the details regarding the company per se, the financial matters or any other matters that the parties would like to bring up. So essentially, I would now like James to let you know about the agenda that we set up, while I will, for clarity, put those agendas on a piece of paper so that everyone knows the chronological order that we will move in order to better sequence the session.
Parties, I completely agree with what my co-mediator said. But I'm of the opinion, this is just a suggestion, it's totally up to the parties, but I'm of the opinion that even if instead of having one agenda set governing a general view regarding the future of the company, I feel it would be better if we split that into future of the company specifically and future of the relationship between the company and Rahul. Because in that way, I feel we will be able to delve into a much more like proper solutions with respect to each of those agendas and explore more options for the same. So that is what the mediators feel and that we are suggesting. But if the parties want it as one single agenda, that's also completely all right.
We're completely all right with the solution. I think we can go with sub-agendas and have a fruitful discussion regarding that.
I think how about within the broad agenda of future of the company, we first understand, and I know that you also have concerns about the current position, and once we can also gain a little understanding about the current position, then I think we would be in a better position, and so would they be to discuss future and about job and employment and whatever they said. Yeah.
Uh, I'm sorry, like you would have to be more clear when you talk about the position. So I answer.
Absolutely. I'll like to clarify that. So essentially, since we're talking about the future of the company under one, like that's a broad theme, right? So what my client is trying to suggest is that under the future of the company, the first thing that we'll have to look at is, of course, where we're at right now. Like, let's say the financial position of the company. What are your future plans? That will only be imputed through the fact that, okay, you're facing some sort of financial issues, or maybe you have some future plans in terms of, let's say, acquisition or buyout or any of that sort of things. So I think my client wants to know your position in that sense. Yeah.
So to put it clearly for Joy, essentially what Karishma essentially proposed regarding your agendas, you would like to discuss the future of the company as regards the present issues that you face. So that is what they would like to be discussed first. So I believe we can move forward now to discussing the future of the company as regards the present issues that you face. You can start with letting us know the issues succinctly that you would like to be addressed under this head once we move forward. And thereafter, once we're done with the agenda, we can go on and discuss the relationship as regards these issues. So I think we can begin with Rahul, and he can let us know about the issues that he faces presently, which hamper the future of the relationship.
Yeah, I think after what all came to light, we have a few preliminary questions about the company. I was the founder, so I still feel some moral responsibility. I also feel curious. I gave it also a lot of time, my inventions, my money, my energy. So first, I want to understand what is the financial situation of Syntax Error right now.
All right, Rahul. It's okay, you have left the company, but you're still the 49% shareholder of the company. You have the majority shares, and you have every right to know what goes in the company. Rest assured that I'm here like a big brother to you. I'm here to take care of all your concerns. Your problems are my problems, and I'm here. I'm not going to leave this table unless and until we all go home happy, right? With regards to the question you asked, the growth of the company, if you want to ask, I would not say it's very high or very low. It's a steady growth for a startup which has been there only like in the last decade. It has a steady growth. We are not in losses. No, we are not in losses. We have profits, but we that is all I can say. I think with regards to the question you posed. Second, with regards to the future of the company, what plans we had, I think in previous rounds of mediation as well, I talked to you about how a Swedish company, Me Devices, is willing to acquire the company, the 100% shares of the company, right? And so we are still talks with the company, and hence I think we want all the interests of that shareholders which are there first to be sorted out first, and then we actually continue holding talks with Me Devices.
I think it would be better here if Rahul, you could let us know regarding the specific aspects of the financial position that you would like for Joy to let you know about. Also, there has been one disclosure of information that is prospects of acquisition by a Swedish company. So that is something that Joy has put forth. But I just request you to let us know specifically so that we may be able to let you know about their answers as such?
Actually, we are asking general questions right now. We're just trying to get a feel of where the company is right now. So we actually don't want to delve into specific aspects. If there's any material change in circumstances, we want to be made aware of that. So which is why we are trying to get a little bit of idea about that. But I must say that it is reassuring to me that the company is having steady growth now. But could you throw a little focus on whether you have any vision in mind about the company? We started it for it to be accurate, for it to build and market inventions which are accessible, available, accurate, affordable.
Yeah. Just to clarify my client's position here, I think what she wants to know is, since you've already revealed that you want to go ahead with the Swedish company acquisition, there were, of course, concerns with respect to that acquisition previously. So I think my client would like to know that are we still in the same position, or like are there any sort of developments that have taken place since that acquisition that was otherwise discussed in the third round of negotiations, if I'm not wrong. So I think with respect to that, my client would like to know if it is still 100% shares being taken over by them and all of that, yeah.
Right. So answering the second question first, which is about the position of the acquisition at this point of time. So the talks with the Swedish company is still going on, and they are still ready to acquire the 100% shares of the company, which means that it would be in the benefits of all the shareholders of the company as well, and it can benefit the company in a great way. When it comes to the vision of the company, I think that is something which Joy would be in a better position to tell you that how exactly is the vision of the company as of now, and how the Swedish acquisition can help the company and the shareholders.
Absolutely. Thank you, Karishma, for clarifying that. With regards to the vision I have, Rahul, you and I both know what dream we had when we started this company. We wanted these medical test kits to be affordable in all parts of India, and we wanted to make the company to the international level. And I think this is where the vision lies, taking the company to the international level, right? The Swedish company is going to acquire it, right? In that sense, we still have the distribution channels. We still have the manufacturing plants as well, right? They'll be acquiring it, and the business. We have not talked about any material change that we will take from the products we're selling right now. But obviously, since we are only in the start preliminary, negotiation rounds with the company, we are firstly talking about the shareholding and the preliminary things we have to. We'll delve into the details later. However, Rahul, as I said earlier, if you have any concerns, you can tell me right now. And since you are the 49% shareholder, have more shareholding than me. All concerns will be rest assured. All concerns will be taken to the Swedish company, and we'll try to accommodate as much as possible.
All right. Actually, we've had a brief discussion about it. And I think one of my client's primary concerns right now is the goodwill of the company with respect to what has happened to the employees. So we've, of course, come to know from the past set of negotiations that we've had that there was, of course, a siphoning off of funds that had happened with respect to the employee gratuity fund, right? So my client right now, because she keeps an ethical position, an ethical and honest position, the idea is that what have we done to remedy the situation? Are there any issues with employees where maybe they've brought up any sort of qualms that they have with the company? Because as you see in the past, 2 times by once a drunk employee and by once another employee. In fact, my client has been made aware of the fact that there are issues going on in the company. So we would like to know that. Also,
Jane, I'd like to interject here 1 second. There has been one offer that was raised by Joy, which might have been missed in the flow of information that we faced. It was regarding your issue of shares and transfer. They were ready to acquire 100% of shares. So if we could let us know your position regarding that offer first, and then maybe we can delve into the other issue separately. So that we can settle upon that point first and then move ahead. Is that okay?
Yeah, actually, we wanted to continue this discussion a little bit because I think it's making a little bit of headway. So I just wanted to also clarify that once I heard from a drunk employee about the patent assignment, The other time, some information, I'm not sure from where I heard that maybe some money is being siphoned out from the employee social security fund. Now this caught me a little off guard, also because I understand that I am an inventor. I don't engage in business circles. I don't engage with your employees. I focus on my laboratory, in my laboratory. So if information is reaching my ears that something has been done to the employees, or that patents assignment, there is some issue with the patent assignment, I wanted to ask, is there any discontent simmering with the employees? Because there must be some talk loud enough that it's making to my ears as an inventor when I don't even engage in business communications.
I do understand your concern, Rahul. I think you have two main problems here. First, if you want to know about the siphoning, or the alleged siphoning of funds you're talking about, and the second about the status of the employees of the company, right? So, Rahul, I want to be very transparent here, right? Uh, I did, in the interest of the company, had to move over the financials for the liquid to actually buy some of the manufacturing plants for the company. However, at the end of the financial year, all accounts were settled. That is, in net effect, and no social security contributions of the employees were harmed in any way. They were given what they actually were supposed to given to do. Right? In practicality, at the end of the financial year, we have filed financial statements and all of them are clean. Right? We had to make certain adjustments in the interest of the company. And I think that only happened in 2014, right? It's been a long time since then. And we were at the start of the company, right? We had to, use some street smarts to actually, just make the company work. You know how startups are in the start. Like you have to, work 18 hours a day. You have to think about what's best for the company. You want the company to survive at every cost, any cost. And that's what I did. So yeah, the employees. So as I said, that the distribution channels and manufacturing channels will be there. So employees will not be harmed in any manner. It will be almost the same since the company is big enough to acquire. I think the revenue and the incomes which is generated in the packages of the employees may also increase significantly. I think Karishma want to add something.
Right. And just because a Swedish company wants to acquire Syntex Limited, it just doesn't mean that it would affect the employees in such a manner, because no employees is actually going to be changed. Employees would be there in the company. It's just the acquisition and the management of the company would be going to Swedish company. So I think it doesn't interfere with the interest of the employees of the company as such. And I don't think there's anything to be worried about on part of Rahul regarding the employees at this point of time.
1 minute, Mrs. Joy, I would like to make a clarification, as in, since we are talking about the future of the company, and since you already mentioned that the employees won't be changed, this is also in terms of a question that Mr. Rahul asked. You had just mentioned that it was your vision to make the company international, and you said that this was one way of doing it by letting the Swedish company acquire your company. So since you mentioned that as one of your vision coming true, I'm assuming that you are actually happy with the fact that your company is becoming international. So I just want to know what would be your role after the acquisition of the company by the Swedish company, because you made it clear that the employees will be the same. Will you also be there in an executive or a managerial position? Is what something that I would like you to elaborate on.
Indeed. So now when we have talked with we had negotiation on with the company itself, we have not gone into specific or personal roles, right? We have only talked company to company, the company to company interest, and not the interest of the CEO, what CEO is going to do or the stakeholders are going to do, right? Right now, as I said earlier, we're in the preliminary talks with the company, right? Right now, we are focusing upon the shareholding or an acquisition which is needed, right? That is the part we're focusing on right now. So I cannot comment at what role will I have. I think we can do that in later rounds of negotiation with the company. But as of now, I do not have anything to say about that.
I sense another common ground that we can arrive at while Joy has given a blanket guarantee as to the future of the employees after the Swedish acquisition. Am I right in stating that that's what you had provided for lastly?
As per our negotiations with the company, they have no plans to change the employee structure of the company, or since they do not have business in India as of yet, right? That is why they want to acquire the company, because they want to penetrate the market itself. So as of now, no, we don't.
And does that answer your query and concern regarding the employees of the company to an extent?
Actually, it does. It doesn't do it fully, and we are on some common ground here, and that's reassuring. But I think we want to continue our deliberation on this issue a little more. And I just want to clarify, Karishma, as to why we are inquiring about the employees. It's actually for, as I said, we want to take into account multiple stakeholders. As for myself, I feel moral responsibility towards the employees, especially if siphoning has happened, right? Then in your case, I understand that even if an acquisition may be in picture today, it may be in picture later on. If the word gets out that some siphoning happened, it's harmful to you because your employees are clearly talking about it, that it reached our ears. Thirdly, even with regard to our employees, your employees, I'm sorry, I still feel for them a little bit. For your employees, if there is something we can do from our end, we would be happy to do so. But before that, would you like to add anything?
Yeah, so I think why my client was asking about the position of the employees is simply because, and I'd like to also clarify that while you state that the financial statements do not in any way show that there has been a siphoning off because, of course, you've returned the money back. However, if you'd know in such transactions, there are bank statements that are made, right, which are kept a hold of throughout the company's functioning. So we're just trying to state that it is indeed a concern because if the employees are talking about it, then the employees are of course affected by the siphoning off. So while you may be returning the money back, it does have something to do with the employees not being in the same position as they would be if the siphoning off did not happen. So I think my client, because of that reason, is concerned about the well-being of the employees. And also the fact that since you would want an acquisition to happen pretty soon. With respect to that, of course, the positioning or the image of the company also is important, right? So if the employees are talking about it, then it could also be that maybe someday there's media coverage of it. We don't want that. And my client would like to, I think, say.
Just before that, please understand that we have something in mind here. We have something in mind for the employees here. I want to clarify that we are not trying to attack you here. We're on the same side, which is why we're in a mediation setup and not in a court setup. So we just want to hear your opinion or your thoughts on this, and then we have something from our side to share with you.
So just 1 second, so sorry. I just feel like, so my client does have an offer to make to you with respect to the well-being of the employees moving forward. But before that, I think my client just requires an answer for the same thing.
Can I take a moment to confer with Karishma?
What I'd like to suggest is at this point of time, we feel that although we do understand what common grounds you have, to better understand your exact interests and what you expect towards the future of the company, I would suggest that we take a caucus with the requesting party as such. And after that, if the responding party would like to proceed with their caucus.
So maybe during the discussion of the offer, we can let you know. But I think we're trying to build the foreground for it and
Yeah.
trying to get their idea.
We feel that we're going in a direction and we do not want to change the direction as of now. I think there's something to talk about here. And I think I understand the concern of the mediators, but if we take it after a little time, I hope you're completely okay with that. It would be better for everyone. So at this moment, I would like to just confirm with Karishma first. Okay, so I discussed with Karishma. Uh, Rahul, I know you care about the employees. Rest assured that the employees are like my family. I'll never do anything to hurt them, right? I do not understand where you're hearing about employees talking about siphoning of money. Since you left the company and I am the CEO and the board of directors are still there, right? None of us got any complaints or concerns from the employees ever with regards to any such siphoning of money or any other problems which relate to it. We make sure that the employees are well taken care of. So I do not think that I understand your concern. While we assure you that that concern will be taken care of, there will be no harm to the employees.
Okay, I have faith in your words. Um, the thing is that it's possible that the employees are feeling a little bit discontent. They may not be at a position where they want to file a complaint, but maybe there is just some tensions. So, and please believe me when I say that I'm on your side here. We're on the same side. It's a mediation setup. We haven't brought this up to attack you. We actually have something in mind. But before that, we want your assurance of remaining on the ethical side. I am an inventor. I don't understand business. You may have to take tough decisions to toil and maybe make compromises. But since I am the founder, I feel some moral responsibility. So I want an assurance from you that you will stick to ethical positions, you will stick to ethical decisions. In what we want to give to the company is 10% shares to the ESOP trust, to the employee stock option trust. In return, we are also expecting a few things, primarily an assurance that you won't delve into anything unethical, even if it's something like taking money out and putting it back, and you might think that it won't come into the financial year records, but even then.
If I could just continue with the offer and if it's all right with you. So as my client mentioned, of course, and also just to clarify, of course, Miss Rahul herself even knew of the siphoning off. So it's not about just the employees, it's about her own knowledge that we know from the previous rounds of negotiations. However, moving forward, what my client would want to provide is, of course, give 10% gift shares to the employee stock option. And in return of that, of course, the primary thing that we'd require would be the fact that you remain ethical, because that is a position she's always taken. But moreover, there are certain other conditions, which we've, of course, been discussing for the past, God knows how many negotiations at this point. But the first one would be waiving off the damages that you've wanted through the legal notice, right, which is 3.5 crores. And along with that, of course, the issue of IP assignment that you're stating that the intellectual property that Miss Rahul owns, the fact that you'd require them to be assigned to the company. So again, we'd want the company to state that they are in fact owned by Ms. Rahul, right? The second thing would be inventor royalty that will be provided to her over the diabetes machine. So she's left the company and she's given that one invention to you that is, of course, very beneficial. That is something that the complete company hinges on. So she would like inventor royalty in that. And there is, of course, a mechanism that we'd propose for the inventor royalty, but we can come to that later as well. It's in next, we would be looking forward to you bearing the tax for the gift. So of course, this 10% shares, and I'll explain the 10% shares that we're trying to provide to ESOP. We'd like you to bear the government tax that you provide for a gift transaction. We'd like the company to bear that amount, because we'll be providing, of course, the 10%, but because we'll be providing the 10% in any such transaction of a gift, there is a tax that has to be paid to the government, right? So we'd want the company to bear that. So these are the 4 conditions, I think, which my client would like to put forward.
Rahul, just to create a better understanding or clarity, when you say 10% of the shares will be granted as gift, are you referring to 10% of the company's share that you own, or the 10% of the 49% of the share of the company that you own?
We're talking about 10% of the 49%.
Okay.
Right. I think there's a lot of information put on the table as of now. First, I think I really would like the mediator's help at this point of time to summarize what exactly was put on the table. And I think after that, my client would like to have a break so that we can just discuss the terms which are put on the table from other side, if that is okay with the other party.
Definitely, definitely. So the offer essentially that was proposed by Rahul was that they would like to ensure the security of the employees, as was a common ground between the two parties. They would like to provide 10% of the 49% shareholding that Rahul has in the company to an employee stock option, uh, which is based on 4 conditions, and they would like that those conditions be fulfilled for the transfer of those 10% of shares to the employee stock option. And there are the 4 conditions are the 3.5 crore damages that have been mentioned through the legal notice, which have to be waived off. Secondly, the issue of transfer of patent rights to the company, which has to be deliberated upon and waived off as such, the fine which comes with it. In addition, 2 new conditions have been introduced, separate from the legal notice. First is the inventor royalty, which has to be essentially borne by the company in respect of the inventions by Mr. Rahul. And lastly, the shares which will, upon the fulfillment of the 3 conditions, be granted to the employee stock option, the tax on those shares to be borne by the company. So, am I clear?
Could I clarify something? So when we talk about inventor royalty over diabetes machine, and help me out, Jane, I think we are talking about the fact that diabetes machine the company owns, but as the inventor, I want to be given some royalty over it. So for the company to pay me some royalty for the diabetes machine they sell, since they're also doing steady growth now.
Hey,
Also, Rahul, when you say the tax should be bared, are you referring to Joy bearing it or the company bearing it?
we're referring to the company bearing it, yeah.
Okay.
So, is that clear, or would you like for me to clarify something again?
No, Emma, I think you clarified it really well. If we have the consent of you, Rahul, we will need a short break to go over the
Absolutely.
terms. We'll come back to you as soon as possible. All right. Thank you so much.
So, do both the parties agree to the break? I'd like to remind you the break would be for 6 minutes, and 2 breaks can be allowed as such. The parties may go to different corners of the room in order to confer.
Joy, we are assuming the mediators expect you to give up your stance with respect to the conditions that was referred, because it's based on that the offer is in existence or not. So first, please make sure that you tell us about your stance with respect to the 4 conditions, and then that will lead us to lead us to know whether the offer still exists or not.
Right. So I think the first thing, which was about the waiving of damages of 3.5 CR, the company is ready to waive off those damages, which is exactly what is asked by Rahul. The second thing, which was about the IPR waiving off, I think we would like to discuss more about this particular term and this particular condition. I think that can happen in the in further in this session. The third thing, which is the inventor royalty, I think even on this particular point, we need more clarifications from your side that what is the percentage of royalty which you are asking and what are the terms and conditions of this particular point. Now, the last condition which you actually mentioned, which was the tax on gifting of shares should be given by the company. We feel that there could be some legal barrier towards it, which is something which can be a technical problem here, which I think can be dealt further after we come to a conclusion on the above 3 points. So I think first it would be better if we talk about the IPR.
Sure, Karishma. So, Rahul, I would like to try to explain to you as simple as possible why we are constantly asking for the IP assignment to the company, right? Right, when we signed the agreement with investors, the first round of investing was done, right? The investment was conditioned on the fact that the IPR rests with the company, and this is what happens in most of the startups, right? Because if that particular IPR rests with one of the founders, the founder can anyway resign and go. Then the investors will lose their money, right? So this is one of the preconditions which are there. You sign the agreement, and we have to, remain in the spirit of the agreement, because we have to remain. We have to take care of the shareholders as well. We promise them that IPR will go to the company. Second is you have your own, benefits of assigning the IPR to the company. You will gain from it. I'll explain to you how. When you assign the IPR to the company, the valuation of the company increases significantly. Why? Because now, since we are a health tech startup, right, we do not rely on a lot of hard assets. We rely on technology, right? If the company has the technology, right, it will drive the revenue up. It will drive the price of the shares up. According to the analysts we have, that if all the IP assignments are handed over to the company, right, in that sense, we have like we'll have 10 to 15 times of the revenue from the price of the shares from the last round of investing, which happened with the PE investment American fund. So when that happens, you own 49% of the company, right? The price of the shares go up significantly, and you gain the most out of it. You get the biggest piece of the pie. So that is why we are, constantly asking you that you please assign this to the company. There are a lot of reasons for that. You have legal reasons, you have logical reasons, you made promises that's good faith, and most importantly, that it is the best deal for you. It is in your own interest.
Before I summarize the offer that Joy would like to make, I'd like for you to make a clarification as to the number of patents or the kinds of patents or the products specifically for which you require Rahul to submit his patents or transfer his patents back to the company.
All right, I'll clarify that. Thank you, Emma, for asking that. I think Karishma also told me something about it. So when we talk about the IPR rights, we talk about the products which are directly related to the business of the company, right? Of course, in his own capacity, if he makes something which is unrelated to the company, we're not asking for IPR rights for that. We are asking for IPR rights for the products of the business that the company is currently dealing with, right? So that there is no problem with the function of the company itself. Karishma, would you like to add something?
Right. So when the agreement was signed, it mentioned the intellectual property rights, which is in the name of the promoter, right? So the product, which is actually something the company revolves around. This is a health tech startup, and it revolves around the product which is actually made. And the intellectual property rights of that particular product should have been transferred to the company, even according to the agreement which is signed by Rahul.
So just to clarify here, and if you're reading the same clause, of course, it says whatever they do make in favor of the company. And as far as we remember, the five, are we referring to the five inventions, or what you mean by the intellectual property assignment? What intellectual property are you referring to? The five that were made before you ever became a partner in this venture, or something that they could have potentially invented after? Like, what are you referring to?
Rahul, as you already know, the main product of the company is the diabetes test diagnostic kit, right? So obviously we're talking about that. Any improvements made upon those particular, products, we're talking about that itself. As I mentioned earlier, all the products which the company directly deals with, manufactures, sells, has to be assigned to the company. It's as simple as that.
Joy, so when you say that, do you also mean that any invention that Rahul made even before he entered into that agreement as well?
Right. So the main product, which, as we mentioned, the product around which the company revolves, that is something which needs to be transferred to the company. Any individual innovation which was done by Rahul in his own capacity, that is definitely not something related to the company. And that is not something which we are asking to transfer to the company.
It is not upon the timeline of the events that what happened earlier before the agreement, after the agreement. The simple thing is the products with the business, the products of which the company does business in, it has to assign to be the company regardless of whether it was made before the agreement or after the agreement.
So correct me if I'm wrong. Your stance, irrespective of the time when the invention was made, if it is related to the business of the company, Joy, you are requesting Rahul to submit the IP rights for that. Am I right?
Right. It is actually also mentioned into one of the clause of the agreement, which is actually signed even by Rahul at that particular point of time. So even according to that clause, the intellectual property rights should actually have been transferred at the time when the agreement was signed. It is even after so many years that those rights are still not transferred, but that is not something which we are getting into. But now what we are getting inside is that those rights now should have been transferred to the company, because that is something which they themselves signed as an agreement.
Right, Karishma, I want to add here that we understand that you think that the other five IPs, the diabetes machine is the company's, there's no conflict there, but the other five IPs, whether or not that should have been assigned to the company is in some gray area. But the fact that all IPs I make were to be signed in the company's name and not in your own name, which Mr. Joy did, is clear. So you can go and impute things in our name, but you have also gotten IPs assigned in your own name rather than the company's name.
I think here we are losing sight of the situation, sense of the issue from Rahul's side. If I may get a clarification on that, that would, I think, facilitate our discussion. It was regarding essentially the five patents. So if you could let us know very, very succinctly whether those five patents form the subject matter of the intellectual property transfer that you intend. Just that one question.
As far as I know, I think three of them are directly related to the product of the company. So that would be required to be assigned to the company.
Yeah, correct. Because that is a clarification that we were wanting to seek. Because when you say that the diabetes machine and everything, so as per the knowledge that we have at the moment, in the legal notice, you said that all patents were, of course, not assigned to you. However, you've never made a specific mention of which ones, which is why I believe we were also confused at this moment on to what the conversation was about. However, my client is definitely clear about it now.
I think what we meant was all the patents which are supposed to be assigned were not assigned. So in that manner, I think it is the right time to call for a caucus. We have to discuss something. So if we may, mediators, can we please call for a caucus?
We wanted the same actually at the moment. So
Rahul,
we'll go right after this. It's all right.
No, if you want, you can also
No,
take the
no,
caucus.
I think.
I tell you, Rahul, I told you earlier also, whatever you want, I want.
I think then we'll go. We'll go and then y'all could follow immediately after.
Yeah.
All right.
Thank you.
Should I escort you to the door? Okay, so just before we start the private caucus, I would like to let Rahul know that this has an extra layer of confidentiality, as in it only stays, whatever you say stays only between the mediators and yourself, unless and until you want us to communicate it with the other party. So keeping that in mind, please put forward any relevant information that you think will help us facilitate this session in a better way.
So I think right now we will do a full disclosure of our interests, and you would understand why what things that they're offering us right now, those interests are not aligning with our interests, and that will be clear to you. So the situation is that I came here with an open mind in all these sessions, but I have realized how muddy these corporate matters can get, and how people can stoop low and they take difficult decisions. I still can't understand all of them. So I have decided I want to shift to the hills. I want nothing more to do with this. I don't want anything more to do with the company, but I still feel some moral responsibility. So because I want my people, my employees to be taken care of, my former employees to be taken care of. So which is why I was offering them ESOP shares, and they must realize that if word gets out, then the value of those shares also dwindles. The acquisition won't happen because European companies are very, very careful, cautious about such kind of financial frauds, even if it's in the gray area. So the thing is, I'm willing to give this as gift, but we want them to bear the gift tax, especially because they are a corporation they can handle. I'm one person, I'm not a corporation. But in return, since I want to get done with all this business communication, and I want to be at peace in the hills and work on my inventions, I want to not have to deal with the damages, and I would like my IP back. If they're so keen to have the IP for the company, maybe we could license it to them.
Yeah, absolutely. I think my client, there are a couple of interests at hand at the moment. First of which is the fact that she obviously wants to ensure that the employees are taken care of, which is why the benevolent gift of 10% ESOP shares, right? Other than that, of course, and why our interests are not aligning at the moment is because they talk about IP assignment to further the share rate or the value of the company, which my client has nothing to do with. She just wants to sell her shares at this point. Why we're not revealing that at the moment to them potentially is because we want to ensure that the conditions that she is putting forward and her interests are first met, which they are actually more or less amenable to, so that is great. But I think because we'd want to sell the shares off, because my client would want to sell the shares off, she would require a premium on the shares. This is, of course, something that we've discussed prior with respect to an acquisition when we were talking about it. But yeah, a premium on the shares that she sells off. We don't have a percentage of the 49% out of that, how much she can sell. For that, we'd actually want to know their, let's say, a pitch when they look at our conditions, and according to that, what they think is ideal. And with respect to, of course, the intellectual property, see, they are not clear either about what it is that they want. Which intellectual property do they think has breached the contract and which is not? And we want clarity over that, and more or less, more than that, even if, let's say, they want the intellectual property rights for the furthering of the company and for the furthering of the acquisition that they want to do, we can, of course, license that. And in terms of sort of mechanism for licensing, we're thinking of an ad valorem royalty on the basis of which we can license it to them. And I'm completely open to talk about the technicalities of ad valorem royalty when they are here.
Yeah. Mediators, I know that you're not fully in the position, and I don't want to digress, but I have a slight bit concern that we've had our entire private caucus over a microphone, and the doors are open, so the information may have traveled out.
Yeah, I assure you that we'll try our best to keep everything confidential. And I think they are staying far away. They're kept far away from the doors, and they will not listen to this. But then, like, I have noted down all your requirements. And from what I understand, Rahul, you want to like give the 10% of your 49%, and sell the remaining or a certain amount of the remaining shares depending on what is the percentage they're like offering, percentage of premium. So I just have two questions here just to create a better clarity. First one being, are you fine if the Swedish company in itself is ready to offer you a premium amount? And the second question being, for a minimum of how much percentage of premium would you like settle for?
I think with regard to the Swedish company, we have a little bit of concern, but I think this can come into picture much later into the negotiation stage, because our vision for the company was to make affordable invention. Now, in a minute, I'll tell you our concern about the Swedish acquisition. And if we are assured, we can go forward with that too. And that is that if a European company, if a capitalist company from a Scandinavian nation acquires our company, then maybe they will monopolize our invention and make the products unaffordable for our people. Our purchasing price differs from the purchasing power of the Swedish people, right? So I think that is a little bit on the back burner right now. But more importantly, about how many shares, Jane, I think I am going to the hills. I want them to agree to our terms. If they regardless, I can give up all my shares provided our conditions are met. Right now, I want to get a picture of them and how many shares they would expect from us. But I don't mind giving all my shares, but this is not something I would want to disclose to them right now.
Yeah, I understand that, but what I asked was for a minimum of how much percentage of premium would you settle for is what I'm asking, because you were keen on knowing how much they would offer. So I just want to know what would be the minimum you would settle for so that we can have a better conversation or a discussion with the other party right after this.
I think 10-15% would be good. I think we could negotiate
10
those
to
specifics.
15% of premium.
We're not married to any particular amount.
Okay.
Percentage.
Yeah.
I think my co-mediator wants to add something.
Also, it was good to know about the offer that you raised regarding the patent transfer. It has been clarified by Joy in the last time that we talked about. There were three essential products regarding the patent of which transfer could be understood. So if it's okay with Rahul, could we, while talking to them in their private caucus, maybe raise this offer of yours about licensing so that maybe when we reconvene, you can go on to discussing about the fine and minute details about the patent transfer?
Yeah, I think we are open to informing them that we could consider licensing not just these 5 IPs, but if I'm in the hills, I hope my productivity increases. I work on more inventions. We could, and I thought we will discuss this in the next agenda point of future collaborations. But I think we could collaborate on licensing future inventions also.
Absolutely. And the reason for not being rigid on IP assignment from their end is also because, as I'm a legal counsel, and I'm, of course, not supposed to bring up the legal matters here, but there's also a consideration of the limitation period for the kind of claims that they are making. So if you realize the inventions that they are trying to talk about is from 2013 and they're trying to bring it up now in 2023. So there's of course a concern with respect to that as well, which is why we don't want them to be rigid on the IP assignment. If they are flexible and they want the inventions, of course the licensing can be looked up to. My client is completely okay with that.
Definitely, because it also forms one of the essential conditions of the broad offer that you had. So with your permission, in the joint caucus, I'd like to disclose that fact. And maybe when we reconvene in the joint session, we'll come to a closure about the settlement.
I think with regard to selling shares, we would want to bring it up ourselves. And with regard to IP, we would also want ad valorem royalty that we will elaborate on.
We'll bring it up ourselves. Thank you.
Okay, so apart from these, apart from the licensing, is there anything else that you want us to reveal to them? Okay. So now if you may, thank you.
Welcome, Joy and Karishma. Quickly to remind you about what our private caucus will entail about. It has an added layer of confidentiality. So nothing you speak in this session will be revealed to the other party in the joint session when we convene later without your express consent. So you can be completely assured about letting us know your deepest inhibitions or any interest that you seek to be addressed in the very near future when we reconvene here. Also, to start you off with, as regards the IP transfer assignment, we have been granted with the permission to let you know about this offer that Rahul was interested in, which was regarding the 3 products that you want IP for. They were ready to consider a licensing option on an ad valorem basis. So that can be discussed upon immediately as we convene in the joint session. Of course, you could also let us know your interest regarding the same offer.
I do have one question about that. So when you talk about IPR of 3 products, so that is apart from the diabetes medical test manufacturing, the 5 other products which we're talking about, 3 of them, they are not willing to give the IPR, but they want to license it. Is that what we are saying here?
In totality, you mentioned there were 3 products that you required the transfer property for.
Okay, so there's a slight problem here. Okay, the main product was a medical test, diabetes medical test kit. When we met in 2013, Rahul told me that there were 5 other products which he had, right? So when he says that for 3 products, he is willing to license them. So then he is agreeing upon the medical diabetes medical test. Oh, they did not tell you anything about it, so we can ask them.
Okay, we'll let you know about the technicality about the number of IPs, but the basis that they were ready to transfer or facilitate the transfer of intellectual property was licensing.
All right.
So that
I
can be
think
one offer that you discuss upon as regards the 4 conditions that were presented in the broad offer. Of course, now you can let us know about what your interests are, what you seek immediately.
absolutely. I think will be better positioned to discuss this offer when all the parties are here. With regards to the interest, we want to reveal to Emma and James is that the primary interest of the company right now is that I'm not representing myself. I'm representing the company. The company sees a very lucrative offer on the table, and we do not want to miss it. Right. As we talked about, the Swedish company Mediavices wants to acquire the company. We want this deal to happen. And this is why we are here to sort out the differences between me and Rahul so that the promoters are on the same page. Right. Because for the Swedish company, it is important for us to see that the promoters are in cordial relationship with each other, have each other's back, and we do not want the Swedish company to have any questions, any doubts with regards to the company because we see it as a good offer. Karishma, would you like to add anything?
I think most of the parts are actually covered by what Joy said. One thing is that we are happy that at least on some points we are on the same grounds, and Rahul and Joy are trying to actually have an amicable solution towards this. There are definitely few other points which I feel that we have to discuss more in the session. But as Joy said, that it is very important because a Swedish company would like to acquire our company, and that would only happen when they are sure that the promoters are in cordial terms with each other. And that is why it is important that promoters and shareholders, which is like Rahul being 49% shareholder, he actually have a cordial term with Joy. And so that for that, I think we are really we have been ready to waive off the damages which they told to us, and I think we are ready to have discussion on most of the terms which they told us, and I think that is very a positive point. We definitely have an offer, but I think it would be better if we tell them directly, or do you think we can?
I think we can make use of. All right, in very simple terms, I'll make the offer on the table, and then I'll explain to the other party as well. So since we have to sell the company to Me Devices, right now we have to pay premiums for that, right? I'm willing to let go of some of my shares right now, and I need, since Rahul is the 49% shareholders, I need him also to let go of around 9 to 10% of the shares. He will be compensated for that, of course. He'll be paid premiums for that. But right now we have to pay for our own premium also. So in order to pay our premium, I need Rahul, obviously, after the later stages, once the premium part is done, the entire acquisition will be there. Then obviously the liquidation preference rule will apply. I think my counsel knows more about that. I'm not very elaborate with that. Karishma knows more about the legal part. So what we want to bring to the table is that we make this deal happen. We close the deal as soon as possible, make the acquisition, and more importantly, that the relationships are mended and we both go on a happy note.
Right. So just to make it easy to understand for both the mediators, Emma and James, I think I would just summarize whatever we discussed in this session, just like very shortly, so that you understand our point of view. Is that we want cordial terms between Rahul and Joy, and for that we are really willing to do whatever is possible from our capacity. We are waiving off 3.5 crore damages, as we have told you. We are ready to negotiate on other points which they told to us. Apart from that, as Joy mentioned, we need to pay premium to the American investors, and for that, even Joy is giving up some of his shares to pay to the American fund. And for that, it is important that Rahul also, as a shareholder, gives up 9 to 10% of his shares at this point of time, specifically 9% of shares, so that combiningly they can pay to the American fund. And in furtherance, in future, actually, it would be beneficial for both, all of them, all the shareholders. Why? Because after a point of time, the valuation of the company would be increasing. And because of that, when it comes to the share, so as a shareholder, the amount which they will be getting, it would also increase. But I think for the benefit, it's now important that some shares are given from the side of Rahul.
We understand the offer at present. We have, both of us have some questions regarding the issues that you have raised in the round. The first is, could you let us know about the economic health of the company, the status that it is in, what reasons are forcing you to consider the Swedish acquisition as the most favorable alternative that you have?
As I mentioned earlier, I cannot disclose all the details of the financial of the company, and I'm sure Rahul gets the financial statements as he is the majority shareholders. He knows about the finance of the company, right? So with regards to that, as I mentioned earlier, we have a steady growth. I cannot bring the numbers down here right now. We have a steady growth, but what we feel is that we are getting a good feeling about this, offer from the Swedish company, since they want to acquire it at a very high rate, right? They are willing to buy this company at a good price. So I think, and they have assured us, like they have talked to us how our manufacturing and distribution will be done, and they have talked to us about a lot of the terms. So there is no, we are not selling this company because we have to. We are selling the company because we want to.
Okay, Jay. So just for us mediators to get a better picture, you said you want Rahul to give up certain like at least 9 to 10% of the shares so that you can pay off the premiums to the American investors, right? So what I'm looking at here is that even after that, for selling the company or for the acquisition, you will definitely need the rest of the shares of Rahul as well, right? So for that purpose, like, are you willing to pay any premium to Rahul for that rest of the shares, which you definitely need for the acquisition? Or, and if at all you're ready to pay the premium, can you just tell me like what would be the minimum that you, maximum you would go for? Just to get a better picture.
I think I can go with the equal amount. I will put in an equal amount. A little less than that would be better because since Rahul owns 49%, I own 40%. So proportionally, I think Rahul should put in more. However, that would, if he doesn't agree, I'll be willing to equalize. But right now, what we want to tell Rahul is that he should be willing to, but do not tell him the numbers right now.
Yeah, no, the question was that if you will definitely need the entire shares of Rahul for the acquisition to happen, right, later on at some point. So for that, after you take this 9 to 10% right now to pay off the premium, for while getting the remaining shares, I'm asking how much would you be willing to pay as a premium, if at all you're ready. That I just want to get a picture on that, that's all.
Right. So just to answer to this particular question,
I will have to interrupt you here. Our timing for the private session has expired. So maybe in the joint session, we can look forward to discussing the same offer that you present and discuss about it if you're willing to disclose the information. Could you let us
right.
know? Okay.
You
Okay, so we can convene to a joint session.
All right.
So I think the private caucuses have been quite a success. Here we got a lot of information about your interests, and it was wonderful to know that a lot of offers that you both have for one another can really come to one same page, and you can move forward towards an amicable solution. I would like to begin with Joy. They would like to disclose an offer that maybe after they do, you could respond to regarding some particular conditions. So, Joy, if you could go forth and discuss about it.
Yes, Rahul. So as I told you about the acquisition reserve, I think we have discussed that a lot. First, we need to take care of the investors, right? The American investor, the PA fund, which is there, which hold 11% of the shareholding. We have to pay premiums to them, right? So what I ask for here is, since we are getting a lot value of the shares after you left the company, also we kept the company going, and we will be significantly increasing the price of the shares itself, and you will have a very good deal. But at the same time, you have to pay premium to the American investors as well. In this deal, I'm not only
So
asking
sorry,
you.
could you slow down? I think my client and I can't understand you.
All right. So what we have to do is we have to pay premium to the American investors, right? I am willing to, let go of some of my shares. I want Rahul to let go of some of his shares, right? So since we were the co-founders of the agreement of the company itself, we have to take care of the investors first, right? So this is what we're asking you to do.
I hear you, and we will take into account what you've said, and we want to add to our prior offer. So, in our prior offer, we had laid down 4 conditions in the interest of time, and that it's running out. I'm sure you have it with you. We are considering you to considering to offer you our shares. To fully disclose, I am planning to shift to the hills. I am tired of business matters. I don't want to delve too much into it. So I want to understand for what percentage of our shares, and please feel to concur with each other, do you think you could accede to our conditions that we had laid earlier?
Also, in addition to that, in terms of the shares that my client would be willing to let go of and of course sell, there's additional thing of a higher premium to be paid on all the shares that she'll be letting go of. Of course, this is not a new concept for us. We've of course discussed this in the third round of negotiations. So we would like, and my client would like to keep that as well. So that's an added condition. So just to clarify, of course, we have first the waiving off of the damages, which you've actually agreed to, which is a pleasant thing. And then, of course, the intellectual property assignment, which we, after our caucus and after deliberating with the mediators, we believe that licensing would, of course, be on the table. If you want any right to the intellectual property, that's, of course, something that my client is willing to provide in terms of licensing. And then third, we're looking at the inventor royalty, which you want more discussion over, so we can do that. And another thing is the bearing the gift tax. And finally, of course, the higher premium. So these are all the conditions. And in terms of that, I think my client's question is, to fulfill these conditions, what percentage of her shares would you think be justified for you to sell?
Because I understand that you are also looking to have some of our shares because you want to pay off a premium, if I understand correctly. Yeah.
Right. I think before Joy answers to any of the questions, I feel there's a lot on this table at this point of time. So I think either we can just clarify a few of the terms from our side right now so that, it eases out the process for both the parties.
Karishma, if you will, I could clarify that for you. The basic two issues that you could answer right now is that the number of shares, the percentage of shares that you would like for Rahul to surrender, along with the premium that you're ready to pay on those shares. So those are the essential requirements.
Right. Sorry to interrupt here. I think, Emma, this is not exactly something which you are mentioning it correctly. Maybe I can put it up in better phrases for all of us. So there's one offer from Rahul where they are willing to give 10% of share to ESOPs. But for that, they have 4 kind of conditions for which they said that 3.5 CR would be waived off and IPR and all of that. These are the conditions, right? We were happy to listen to this offer that they are willing to give 10% of shares to ESOP. On the other hand, what we are asking is that we want Rahul to give up some percentage of his shares And at the same time, Joy will also give some percentage of his shares, and these shares would not be for the purpose of ESOPs, going to ESOPs. These would be for the purpose of paying premium to the American investors. And once these premium is paid, which is actually that both the shareholders give up some of their shares and pay premium to the American investor. So these shares which we are now asking you to give up are actually different from the 10% of shares which you are planning to give up.
Okay, so the thing is, the 10% shares that I give up to ESOP Trust still leave me with 39% of my equity shares. Now, the thing is, I am going to the hills. I don't care about modalities too much, about a little some percentage here and there. I understand we want to discuss. You would like to discuss this, and we can continue it in the future. But do you have any number in mind?
Before that, we need certain clarifications because the numbers are getting confusing right now. In the start, you talked about you will give 10% of your shares for the ESOP. You have 49%. 10% of that would be 4.9%. Right. In that case, you will have around 45% of the shares still with you. Could you please clarify that?
No, actually, what we were trying to state is 10% from the 49%, which would again leave us with 39%.
I think being the science person here, 10% of 49% would be 4.9%. If you take away 4.9%, not 45, but about 44.1% is left.
Right. So my client is not really that good with mathematics at this point of time, but even that, still, I think that is something that what my client mentioned and not 39% which you mentioned.
Yeah, I think Miss Rahul, I think there was definitely an error on my end, so I apologize. But yeah, so we definitely have 44.1% of the shares remaining. And what she's trying to talk about at the moment in terms of selling the shares is not what the 10% is, but after that, whatever is remaining, she's asking what percentage of that would you be willing to buy for all the conditions, additionally another premium on the same year.
Yeah, and I know that for you to quote a percentage, you want to have a further discussion on each of the respective percentages of things, because then you'll be in a better position to quote your number. But okay, I will lay all my cards on the table, because I'm an inventor. I can't wait to get back to the laboratory. I'm done with these sessions. I can't wait to go to the hills and work on my inventions. So I will tell you this much, that I am also willing to give up on all my shares, provided that the conditions I lay down are met. I think we could maybe over Zoom call, we could my representative and your office could finalize the numbers. But I think things as they stand, could you reiterate our conditions, and if you could
I think we have understood. Yeah, yeah. So if we can comment on that. So what you're willing to do is you'll give up on all the shares for the acquiring from the Swedish company. For that, you want higher premiums for those particular shares, right?
There is a clarification regarding that. She's not.
I'd like to remind both the parties, I'm sorry, as you know, in the beginning, we said that this is a time constraint session that we have. And looking at the wonderful pace at which we have proceeded, there are lots of offers that have come to the mediation table, which could not be decided in the paucity of time that we face. So we could quickly summarize the two offers that have come from both the sides, and we can move on towards setting a date for a subsequent session to begin with discussing the offers that we now have.
Yeah, Miss Mediator, I think they were asking for a clarification. So if you can just answer to that, because it'll just leave us on a better note, I believe. So in terms of what they're asking and the shares that I think you require a clarity, could you just repeat what you require a clarity on, please?
So like there was some confusion the percentage of shares that you have that you're willing to give up.
Yeah.
All right, as Emma mentioned, I'll repeat my offer. Go home, think about it. I think in the next session, I'm absolutely sure that we'll be arriving at a conclusion. Our offer is we are willing to sell the entire company to the Swedish company. For that, first of all, we need you to assign the IP rights to the company, which will be done by obviously all the promoters, right? The valuation of the shares will go up. We want to get the best deal. How do we get the best deal when the valuation of the company is high, right? If we make the valuation of the company high, right, we are at better position to negotiate with the Swedish company. After that, we need you to, give up some of the shares for paying premiums to the investors, American investors. I'm willing to do the same. Please go home and think about it. And after that acquisition will be done, we all go home. You can go to the wish you had that going to the hills, you want to work on liability. I'll keep visiting you. I think we should remain cordial. I think we will remain friends. I think we are a lot better than previous sessions. And I hope you go to the hill station with a lot of money.
Right. So I think our cards are on the table that we are we can give up all our shares provided our other conditions are met. And I think the modalities of other conditions can be discussed in the subsequent meeting, hopefully with lesser and lesser of my involvement.
Yeah, absolutely. Also, I think just another clarification with respect to the fact that you stated the selling of the shares are for the acquisition by the Swedish company. So with respect to that, I don't think my client is very comfortable yet to state that the acquisition of the Swedish company should be the way to go about it. There are multiple things that my client and I were deliberating on, maybe let's say about an ethical check that can happen on the Swedish company, and on the panel of which a representative of my client could also be a part, right? Another thing could be, let's say, a contract where they state that the price caps that they'll keep for the products after their acquisition will be a certain degree. I'm so sorry. Yeah.
We will discuss more options regarding the same in the future. We will set as close a subsequent date as we can, because there are lots of offers which you need to think about. However, I hope that now that you better understand the interests of the other party through the course of our session today, you will go home and think about the offers that we face, and we'll probably convene next time and get into the intricacies of those offers.
Also, as we can see, we have indeed made significant progress with respect to waiving off, which has already been agreed, and the licensing as well as the selling of shares contingent on the high premium. Both the parties are ready on discussing that. So we have indeed made a progress. So I request both the parties to consider that progress, acknowledge that progress, go back to your home with the same enthusiasm to come back, sit, discuss, and calmly come to an amicable solution in which both the parties can share a win. So let's leave on a good note.
Thank you so much, James and Emma, for mediating this session. I think with your help only, we were able to, go towards the right direction. And even though we did not come to a solution yet, but we have made significant progress. And I would like to thank both the mediators for doing a wonderful job.
Likewise, I think we have had a fruitful discussion where we know what each other is looking for. And I think we are in a position of giving each other that. And perhaps in the next session, we could iron all that out.
Just that word, we have any questions, so starting with you.
How many minutes to go?
15 minutes.
So, better.
This is one there. Say that when boards stand up, we are in a mediation. What do you think was the evidence of drawing in a hand? Sitting in a meeting.
Right. At that point, when we continue to ask them about how are the employees thinking, that was part of our strategy, because we wanted to offer them the sub 10% gift. So we wanted them to value it and for the employees gift to the ESOP, because then they summary pension of the employees, we need to quell that concern, and this 10% will help in that, because the employees something for us. So that way, we were trying to make them value what we were giving to them. But inadvertently, they thought that we have some ammunition to attack them for siphoning off the money, or maybe we have heard something from the employees, and like maybe our confi has something about that. So which is why I think they were becoming a little defensive. So I just wanted to assure her that we are not in a court setup. We are on the same side since this is mediation. This was our intention, sir.
I have one question that I want each party to sort of answer. When you got into this mediation today, did you have a mediation strategy before you came in? What was it? How do you think it panned out? And what could you have done differently? Quickly, don't go overboard. So quickly, if you can go back to that. And specific questions are with you is, at the point you actually said that the price is not relevant. What is your thought behind it? And for the other mediating table, there was a point in the caucus was discussed by the mediator. I don't know why you say not done. So there was a discussion that happened with the mediators trying to think about a session that should we have independent session, that you said we give that later. So at that point, why did you not take it and move towards a caucus? So that's your question. And for you, that's a question. And otherwise, just in terms of what was your mediation strategy when you got into the
Can I answer first? Thank you so much for that question. So first, I'll answer the mediation strategy question. So our primary interest here was to make this deal happen as soon as possible. For that, what we wanted to do was make them think that, give a solution to them, which everyone thinks is good for them, right? If we force them to give IPRs according to contractual obligations, then we are not doing anything fruitful in mediation session. Our strategy was to listen to them, willing to take care of the interests, right? And give them a solution which benefits not only us and them as well. And that is why we're reiterating again and again that we're willing to give a solution which helps every one of us, right? And then everyone was happy, right? So that was a mediation strategy. We did not take the attacking approach, right? Because we feel that is more for the litigation. This is a mediation. We felt because we have contractual obligations which are in our favor, but we did not bring that up to force them out of them. With second question, you mentioned that we said we can take the caucus later. I think you're talking about that. So, ma'am, at that particular point, what we felt was that the caucus is taken at the time when there's a particular impasse between the teams, right? When there are conflicting things which are happening. At that particular time, I think there was a fruitful discussion going on in a good direction, right? So we felt at a point when we are actually disagreeing with each other, that would be a better point to take help of the mediators, talk them out, and tell them what our interests and positions are, so that they better understand it, and then we resolve those particular issues.
And as you mentioned that that your interest was selling the shares. Would you have done anything differently to sort of get to the point where your interest was brought on the table first? And you said that it was also to make sure that your interests were aligned. So what was their interest? What do you think during the conversation? What do you think came about? What did you understand of their interest?
I think most of the time their interest was with regards to the morality and the ethical concerns which they had, which they talked about again and again. Then the second interest they had was with regards to the employees, that the employees are well taken care of. We've tried our best to take care of both of the interests, that we assured them that the employees will be well taken care of. And we promised them there will be no ethical problems which will be happening right now in the future as well. So that is why we tried our best to take the interest in as much as possible. However, I think we could have been a little quicker in coming on to the solution, right? The solution which came, I think there was a little more time which was taken. If it had come earlier, we could have delved more into that, because at the end of the session, there were still terms which were not discussed, which we had now have to take another session for it, right? So I think that which we could have done better.
I think he has covered most of the points, but I think that was mainly a strategy, as he mentioned, and about the caucus also. I think there was some clarification going on between both the parties, and at that point of time, when mediators said that we can go for a caucus, we just felt that it's better to clarify things first rather than going into a caucus and coming back and forgetting the points we were actually having clarifications on. So I think that was something which we thought at that point of time.
I think our strategy today was first, as we explained to sir before, that we wanted to lay a foreground where they value why we are giving them an ESOP. And since past confi tells us that we are a moralistic person, we also wanted to drive home that we value the company, its employees. That's why we are doing it for them. And we also told them that you are in a better position because of this gets out, the value of your share dwindles. Another thing in our part of our strategy was that when we were asking initial questions about what is your vision and what is the financial situation, we were using that to tweak our offer because that was giving us information about what their interests might be. So that was our strategy to begin with, and I think that worked in our favor. And to a great extent, I think we were able to milk that strategy. Later, ma'am, what I think we could do differently, in my opinion, was that we wanted to elaborate a little more about how in Swedish acquisition, once I sell off shares, I would still want to control who it sold off to and not a capitalist company in Scandinavian nation. So we wanted to work in, if it happens, a clause that you place a price cap. But I think if we managed time maybe slightly better, we could have had a more rounded discussion on it. We were only able to mention it at the end. And after that, I think we'll return to the price being relevant question.
Yeah, I think adding to what she said, I think one thing we could have done a lot better was maybe bring about the selling of shares a little prior to when we started discussing it, because right after that, we started a lot of our creative solutions as well. Then it started making sense, because at one point they were letting us know that if we give them the IP assignment, then the share prices go up. However, at this point of time, my clients' interests were not to gain anything more in terms of an equity stake in the company, but just to sell it off, to keep the IPs with her, because she is the inventor, she is the mastermind, and she just wants the IPs. In lieu of that, we of course gave them a licensing preference. I think if we wanted to deliberate on that further, we would have even brought up, let's say, a co-ownership of the invention, right? Which is essentially when they are also an assigned owner and so are we. So without my client's consent, they couldn't license it to anybody or they couldn't commercially utilize it anyway. So all of these communications could not happen, I think, because of how late it was.
Ma'am, to briefly answer your price not being relevant question, ma'am. So I think I just want to clarify that when we said this at the end, it was said in reference to how when they were talking about, oh, but about inventor royalty before agreeing to anything we want to give, whether like what amount of royalty are you expecting? We just wanted to drive home the fact that I'm going to the hills. I don't care about this too much, because at the end, we just wanted to throw in that we are willing to give you all shares. So these nitpicky things we don't really care too much about, and this can be sorted in the next session. So don't be rigid about this, because we are not. Yes, ma'am.
The mediators, just one question each. So when you, and this was something that happened in the caucuses. So when they called for a caucus, started with a question. Why did you start the question first? And for you, it is when you ask them, the first question is, how much would you settle for? Why was that such a important question for you to ask?
Thank you, ma'am. So, as we had the requesting parties caucus first, and we ended it with the question about whether they'd like for this offer to be to be made known to the other party through the mediators, and when they acceded to that, I thought it relevant to mention that offer first, because both the parties had this settlement-oriented approach today from the very beginning. So I thought if that could be used to some advantage of both the parties in coming to the joint session and quickly deciding upon the conditions, because they already know about the offer as such in the private caucus. And if there are any inhibitions which again could relate to that offer, they could let me know in the private caucus itself. So that could have been to an advantage as such.
Ma'am, with respect to the settling part, what I was trying to do was that I was sure that since the requesting party, that is Mrs. Joy, was very desperate for the acquisition, I was sure that they want all of the shares of Mr. Rahul, because without that, they can't have 100% sale of shares to the Swedish company. And the moment Mr. Rahul also said that he wants to go to the hills by selling all the shares, what I saw there was a kind of a settlement where he will get what he wants, she will also get what she wants. But the only problem was that Mr. Rahul demanded for a higher premium. So the only hindrance that was lying down there between both the parties in main position or interest was the premium. So if at all Mr. Joy agreed for that premium, then there comes the direct settlement of the selling of shares, because Mr. Rahul ka like interest of going to the hills by selling the shares also will work out. Them getting all the shares so that they can give it to the Swedish company will also work out. So I just wanted to ensure that what would they be settling for, and that's exactly the same thing I was trying to get it done in their caucus also. If I had got a little bit more time, I would have found out. Like, they specifically asked me not to reveal regarding the shares. I was only allowed to reveal regarding their IP, licensing of IP. So I couldn't have directly went and asked this party, told this party that they will settle for 10 to 15% of premium. So are you ready to give that? That I couldn't have presented because they specifically said that they want to present it themselves. So that's why I went and asked them how much would they be willing to give maximum, so that if I get an idea there, then and luckily, if at all they allow me to introduce that in the joint session, then the moment the joint conference starts, I would tell them that they are willing to pay a premium of 10 to 15%, or if at all they allow, and that would lead to a direct settlement. So in that case, waiving of damages is also agreed, and the major, like the shares part is also settled. So in that case, I thought we could get in this one session itself one more aspect settled down, so that in next session we don't have to worry about that anymore and can go directly to IP licensing or whatever the other matter could be. That's what I was thinking.
Sir, anything to add? So questions? Sir?
So unlike my esteemed panel judges, I have background, more than practice into theory. So I have some one or two small minor questions from your theoretical preparatory part. First to this can be a joint question, both of you. What was your, explain about your strategical part on the practical aspect? Sorry, were you competing or you're cooperating, or you are in kind of a mix of? If you were cooperating, was the disclosure of information full and open, or it was somewhere between?
Yes, I to what he is asking. An example, in your concern, you had kept some shares with some patents with you. You never disclosed in the discussion part of it. Why? What at the end of it, nothing has happened so far. This is one. And both of you, the idea is that the company is in financial trouble, isn't it? Company is in financial trouble.
We have no such information regarding that. We were not told anything
Where
about
was
it.
the need for all these negotiations or all this? It's only because of a misunderstanding between both of you.
Yes.
If there is a misunderstanding, when the other partner wants us to leave the company, why not you have accepted that instead of going for kind of via media negotiations for part shares to be taken? Both of you can answer this question.
That's what. And for a mediator, linked with theory. Sorry for it is a theory. I mean, panelist has walked in that, knows that a pure facilitating but it appears to me at least one of you were largely moving around the role of the facilitator. So what made you to take that decision? Which is like one has more allowing the parties to take command. So
So, I think for the question you asked earlier about cooperative, I think in my opinion, Nasta can add, we thought that we were cooperative for the most part. And I think when we were getting a little messed up, and we thought that maybe they don't think our interests align, or maybe they think we are attacking them while asking about employees, I think we tried to get more information and allay our concerns. And when I thought that it was getting difficult and taking a lot of time to convey that our interests are different, I think we took a caucus. And then, sir, after we can talk about the full disclosure.
Correct. So with respect to competitiveness versus cooperativeness, I think we came in with the strategy that we'll be cooperative as much as we can. However, at the back of our mind was, this is the final confidential information that we've received, in which we've actually been given all the access. We can give them whatever they want. And for the past 3 to 4 rounds on all our confidential information, either we did not want the communication to happen, or we didn't want the merger to happen. So we always had such conditions. So in the back of our minds, and because we've also been told that these are subsequent confidential informations that become a part of your general information, we didn't completely want to let go of all the conditions we've had so far, because then it will look foolish on our part that we've been arguing for so long, and at the last helm of affairs, we're like, okay, take everything. We don't even want anything in return. So the idea...
So with regards to the conception of theory and practicality, we had some personality traits of Joy. And from the general information also, we know that he's sort of a street smart person. He's sort of a little different person in that way, that he gets what he wants, but he's also smart. In that case, they were not grilling us about the IPR which we have in our names. They just mentioned in the past, but questioning us indirectly, right? It was one of the things they said. So we did not feel the obligation to come here and accept it without their, asking about it. However, I did at a later point of time in passing also, when I was asking them to assign their shares, I mentioned in the passing as well that you do the same, and I also will be willing to assigning the shares, assigning the patents as well. But we were avoiding that territory because it could be problematic for us.
Excuse me, sir. Sir had also asked about full disclosure questions. Sir, would you want us to answer that also in 30 seconds each, sir, about full disclosure? I apologize, sir. Sir, so I wanted to quickly add that, yes, we did go forward with full disclosure, sir, because we were told in our confi that Rahul wants to go to the hills. So our BATNA just became that we could leave for the hills and maybe preferably have our damages waived somehow. And I think we managed to get that today anyway, sir. So with regard to BATNA also, full disclosure worked in our favor.
Sir, as regards the facilitator's role of a mediator, initially when we learn about mediation, it is told that a mediator's role is only as a facilitator. But through the course of these 5 rounds, we've been grown to learn that it is a facilitator only in the beginning to get the flow of conversation. Whilst offers are being discussed, you have to play a more active role, because the parties would not necessarily agree to each other's offer. So you have to present the offer in a way that it seems the most attractive to the other party, and they come at a resolution. So it changes from being a facilitator's role to being a more active role in the whole process as that.
Yeah, so to answer your question, I feel that I initially, like she said, I also felt that I was also only facilitating by summarizing or repeating or clarifying. But I think towards the end, I started to become a little active as well by trying to ask them relevant questions and trying to gather information regarding the premiums, and also that apart from just summarizing what they already have said, I tried to bring something new into the table to gather some new information. So I believe that by doing that, I was moving a bit away from just a mere facilitator to an active role. And regarding the role division that sir asked, no, we had no role division as such, as per se, in who will be more active, who will be less active. There was no such role division. The division was only regarding who will be in charge of the requesting parties, private caucus, who will be in charge of the responding part. That was only a role division. Everything else was just according to the moment and the momentum of the session that was happening.
mediators. Final round, very confident that we have funneled down the issue and we're in a position to close the deal. How confident?
Actually, in the beginning, when they said that they all started compared to the other rounds, they, like in this session, they started off the mediation in a very positive way. They were almost on the same ground, so we were actually confident that we can come to a settlement. And even right now, I'm very confident that if I had gotten a bit of 15 or 30 more minutes, I could have actually come to a settlement with respect to the shares and already the damages. The company already agreed that they can waive it off, and they were also coming to a settlement where they're telling that they can license it off, and the only condition that was remaining was regarding how much they would pay for the licensing. So like it's not, it's the like by the end of the session, there was no problem as such.
Not qualifying the issue, but it was funneled down to the.
Yes, sir. So what I feel is that, so one more point, sir. So what I feel is that, like everything was coming to an agreeable terms, even though like it was not completely agreed. So I feel that if we had got a little bit more time, that could have been completely agreed upon, is what I personally feel. So I still feel confident about that.
Both the parties came with a settling initiation today. So it felt like discussing about the future. They were presenting a lot of offers. So that funneled it down to both of them being concerned about the future of the company while presenting offers that they were simultaneously agreeing. So I believe it was a perfectly set agenda as they were both on the same page.
Thank you very